Hello, ladies and gentlemen, it's Mike here at Game From Scratch, and some massive news in the world of game development, specifically in the world of Apple game development, because Apple just got sued for antitrust by the Department of Justice. Now, this isn't normally the kind of thing I would talk about on Game From Scratch. It's more of a, I don't know, business or politics topic, but this one intersects with game development quite a bit, especially going back to August of 2020. Epic Games launched a lawsuit against the app stores, both Google and Apple app stores, after Fortnite was pulled because they added the ability to buy V-Bucks on them. Basically, Apple had this all set up, and they were arguing that Apple was actually a monopoly, that they owned a monopoly on the areas they were at. And sadly for Epic Games, in 2023, well, they pretty much lost. So there were some things that Apple was found to be in violation of. They had to open up parts of their store, which they followed through with some pretty malicious compliance. But that was pretty much the end of it. No, not necessarily the end, because actually literally right now, Tim Sweeney is probably drunk as hell, but Tim Sweeney is down in Australia fighting the good fight still about the same thing. But while that was happening, wow, did this one ever happen. So the Antitrust Division of the U.S. Department of Justice, basically the people in charge of making sure that people don't abuse monopolistic power, well, they issued a statement today. Merrick Garland, the head of the Department of Justice, issued the following statement. So the Attorney General, Merrick Garland, said, "Good morning. Earlier today, the Department of Justice, joined by 15 states and the District of Columbia, sue Apple in the U.S. District Court for the District of New Jersey for violating Section 2 of the Sherman Antitrust Act," which, by the way, is exactly the act that Epic Games were suing under originally. Over the last 2 decades, Apple has become one of the most valuable public companies in the world. Today, its net income exceeds the gross domestic product of more than 100 countries. That is in large part due to the success of the iPhone, Apple's signature smartphone product. For over a decade, iPhone sales have made up the majority of Apple's revenue. Today, Apple's share of the U.S. performance smartphone market exceeds 70%, and its share of the entire U.S. smartphone market exceeds 65%. Apple charges as much as nearly $1,600 for an iPhone. But as our complaint alleges, Apple has maintained monopoly power in the smartphone market by not simply by staying ahead of its competition on the merits, but by violating federal antitrust law. Consumers should not have to pay higher prices because companies break the law. We allege that Apple has employed a strategy that relies on exclusionary, anti-competitive conduct that hurts both consumers and developers. For consumers, that has meant fewer choices, higher prices and fees, lower quality smartphones, apps, and accessories, and even less innovation from Apple and its competitors. For a developer, that has meant being forced to play by rules that insulate Apple from competition. And as outlined in our complaint, we allege that Apple has consolidated its monopoly not by making its products better, but by making other products worse. Apple carries out its exclusionary anti-competitive conduct in 2 principal ways. First, Apple imposes contractual restrictions and fees that limit the features and functionality that developers can offer iPhone users. Second, Apple selectively restricts access to the points of connection between third-party apps and the iPhone's operating system, degrading the functionality of non-Apple apps and accessories. As a result, for the most of the last 15 years, Apple has collected a tax in the form of 30% commission on the price of any app downloaded from the App Store, as well as on in-app purchases. Apple is able to command these fees from companies of all sizes. Apple has also suppressed the emergence of programs like cloud streaming apps, including gaming apps, as well as super apps that could reduce user dependence on Apple's own operating systems and expensive hardware. And as any iPhone user who has ever seen a green text message or received a tiny grainy video can attest, Apple's anti-competitive conduct also includes making it more difficult for iPhone users to message with users of non-Apple products. Just a quick aside, this one strikes me as this is very personal. So I think Merrick Garland is either an iPhone user that has Android people texting him or the opposite, because this one, again, is a very specific example that I think a lot of people will understand and relate to. It does this by diminishing the functionality of its own messaging app and by diminishing the functionality of its third-party messaging apps. By doing so, Apple knowingly and deliberately degrades quality, privacy, and security for its users. For example, if an iPhone user messages a non-iPhone user in Apple Messages, the text appears not only as a green bubble, but incorporates limited functionality. Conversation is not encrypted, videos are pixelated and grainy, and users cannot edit messages or see typing indicators. As a result, iPhone users perceive rival smartphones as being lower quality because the experience of messaging friends and family who do not own iPhones is worse, even though Apple is the one responsible for breaking cross-platform messaging, and it does so intentionally. For example, in 2013, a senior executive at Apple explained that supporting cross-platform messaging in Apple Messages would simply serve to remove an obstacle to iPhone families giving their kids Android phones. In 2022, Apple CEO was asked whether Apple would fix iPhone to Android messaging, the questioner added, "Not to make it personal, but I can't send my mom certain videos." The Apple CEO responded, "Buy your mom an iPhone." In addition to selectively controlling app distribution and creation, we allege that Apple is violating the law by conditionally restricting developers' access to the interface needed to make an app functional and on the app operating system. So this is access to APIs, etc. For a product like a smartphone or digital wallet to be useful to an iPhone user, it must be able to communicate with the iPhone's operating system. Apple creates barriers that make it extremely difficult and expensive for both users and developers to venture outside the Apple ecosystem. When it comes to smartwatches, Apple not only drives users to purchase an Apple Watch, which is only compatible with an iPhone, it also uses technical and contractual controls to make it harder for someone with an iPhone to use a non-Apple smartwatch. When it comes to digital wallets, Apple exclusionary conduct goes a step further. Digital wallets allow users to store and use passes and credentials in a single app, including credit cards, personal information, movie tickets, and car apps. Apple Wallet is Apple's proprietary digital wallet on iPhone. Apple actively encourages banks, merchants, and other parties to participate in Apple Wallet, but it simultaneously exerts its monopoly power to block these same partners from developing alternative payment products and services for iPhone users. For example, Apple has blocked third-party developers from creating competing digital wallets on iPhone that use what is known as tap-to-pay functionality. That is the function that makes a digital wallet, well, a wallet. Instead, Apple forces those who want to use the wallet function to share personal information with Apple, even if they would prefer to share that information solely with their bank, medical provider, or other trusted third parties. When an iPhone user puts a credit card or debit card into Apple Wallet, Apple inserts itself in the process that could otherwise occur directly between the user and the card issuer. This introduces an additional potential point of failure for that privacy and security of Apple users. And that is just one way in which Apple is willing to make iPhones less secure and less private in order to maintain its monopoly power. The Supreme Court defines monopoly power as the power to control prices or exclude competition. As set out in our complaint, Apple has that power in the smartphone market. Now, having monopoly power does not itself violate antitrust laws, but it does when a firm acquires or maintains monopoly power, not because it has superior products or superior business acumen, but by engaging in exclusionary conduct. As set out in our complaint, Apple has maintained its power not because of its superiority, but because of its unlawful exclusionary behavior. Monopolies like Apple threaten the free and fair markets upon which our economy is based. They stifle innovation, they hurt producers and workers, and they increase costs for customers or consumers. If left unchallenged, Apple will only continue to strengthen its smartphone monopoly. And I have a feeling that that might be part of what caused this. The malicious compliance and the just pure arrogance that has been coming from the Apple camp in the last couple of years probably pushed this, especially with the EU bringing out their own protectionist laws as well. I think this is somewhat of a response. But there's a law for that. The Department of Justice will vigorously enforce antitrust law. Enforcing the law protects consumers from higher prices and fewer choices. That is the Justice Department's legal obligation. That is what the American people expect. That is what they deserve. I am grateful to the attorneys and staff of the department's antitrust division for their tireless work on this case on behalf of the American people. I will now turn the podium over to blah, blah, blah. So, yeah, those are the words directly from AG, Merrick Garland. Apple is under antitrust. This is exactly, actually, I would actually argue that this goes well beyond what Tim Sweeney at Epic was aiming for when they first launched their lawsuit against Apple. But they nailed it. They nailed all of the various different areas where Apple has been abusing their platforms, and specifically, about locking developers out, locking away API accesses, forcing people to use their payment mechanisms, and so on. And also, like I said earlier on, part of this felt very, very personal. When we start getting into the messaging, this part right here, this sounds like a personal slight. But I also think it's one of those areas where a lot of people that are in or outside of the Apple ecosystem will really relate with it. So it's probably a good example to consumers about where Apple has ruined their own product to sell more products or to lock in their consumers. So massive news. The Department of Justice are filing antitrust lawsuits against Apple. And again, somewhere there is a very happy, very drunk Tim Sweeney. And the funny thing is, if the Department of Justice had just done all of this, Epic would have never launched their crusade in the first place. But huge development. I'm curious what you think. Let me know in the comments down below. I'll talk to you all later. Goodbye.